Starting from July 2024, the Australian government has started enacting substantial immigration changes that will impact a number of visa subclasses and programs. Many potential applicants and current visa holders in Australia, including companies, are impacted by these changes, which range from higher visa application fees to more flexible employment conditions and the elimination of some visa streams. We'll explain all you need to know about important Australia visa regulations starting from July 2024 in this video, even though certain changes, like the soft cap on the number of foreign students, are still being worked out. 1. Additional 10,000 visas in Western Australia. An agreement for 10,000 skilled migration spots for the 2024-25 fiscal year was signed by the Western Australian and Commonwealth governments, marking a significant step towards addressing labour shortages and promoting economic growth. The economy of Western Australia stands to benefit greatly from this deal, especially in the area of residential building. The agreement directly addresses the needs of the sector to fill positions that are not filled locally. The State and Commonwealth governments' cooperation demonstrates their dedication to using strategic skilled migration to maintain and grow Western Australia's economy. 2. Partner visa update. The Family Violence Clause no longer requires applicants for subclass 309 and 100 visas to be physically present in Australia at the time of decision-making. Applicants may now make use of this clause if they arrived in Australia after submitting their visa application. However, this implies that applicants are ineligible to use the family violence provisions if they have not visited Australia since filing their application. Since the department permitted the visa to be awarded with applicants on shore, visiting visas for subclass 309 and 100 visa applicants have been subject to heightened scrutiny. The department raised the application fee for a partner visa to $9,095 as of July 1, 2024. 3. Introduction of a new workplace justice visa. Under the subclass 408 temporary activity visa category, a new stream known as the workplace justice visa has been developed to give victims of worker exploitation a way to stay in Australia while they legally pursue their claims before the appropriate authorities. By enabling temporary stays in Australia for a duration of 6 to 12 months, with the possibility of extending their stay for a maximum of 4 years through multiple visa renewals, the new initiative seeks to safeguard the rights of visa holders. This is a component of the government's plan to lessen the possibility of migrant exploitation and guarantee that employees may seek justice at work without being constrained by their visa status. 4. Changes to the graduate visa program. The age restriction for the subclass 485 visa program has been lowered to 35, and the relevant streams under which an application may be submitted have been renamed by the department. With this modification, applicants' visa validity periods are shortened, and the maximum number of consecutive visas they may have has been reduced to 4. The post-study workstream was renamed the Post-Higher Education workstream, while the graduate workstream became the Post-Vocational Education workstream. 5. Visa restriction for some applicants. Some holders of temporary visas will not be able to apply for a student visa while they are in Australia from July. This strategy seeks to curtail visa hopping and reduce the number of permanently temporary former international students residing in Australia. Certain visitors and temporary visa holders will be impacted by these changes, and those in possession of temporary graduate visas are advised to depart Australia and seek alternative visa pathways that may result in permanent residency or pursue skilled employment. A student visa must be applied for outside of Australia for those with a visiting visa who wish to study in Australia. 6. Mandatory medical test for visa applicants. Regardless of the status of their current passports, all visa applicants over the age of 15 who were born in a nation with a high risk of hepatitis B will need to undergo obligatory hepatitis B testing as part of their visa health examinations as of July 1st. This implies that as part of the health assessment process, candidates for both permanent and provisional visas who were born in a high-risk nation and then became citizens of a low-risk country and are older than 15 will need to undergo the hepatitis B test. That will be all in this video. Please share your opinions with us in the comments area. Don't forget to like, subscribe, and enable the notification bell to receive updates on job and immigration news. Thanks for watching.